rise. The Court of Appeals Division 1 is now in session.
Please be seated.
This is the time and date set for oral argument in CV 21-0197, Richard and September Neville versus Stephen and Leslie Beck. These proceedings are being video and audio recorded as well as live streamed, so I ask you to please introduce yourself and your client at the beginning of your argument. I would also let you know that Judge Howe has been exposed to COVID. He does not have COVID, but he is watching this on the YouTube for the safety of all people concerned. All right. Each side will have 20 minutes to present your argument. Appellant is responsible for watching the clock to reserve a portion of that time for rebuttal should you choose. We have read the briefs. We've discussed this case in conference. We're familiar with the facts. Please bear that in mind during your presentation. At this point, counsel, are you ready?
We are, Your Honors. Good morning.
Good morning.
My name is Darlene Twiss. I am the attorney, along with Christopher Combs, for the appellants Richard and September Neville.
Please
May
proceed.
I continue with you?
Yes.
Okay, thank you. At this time, I would like to reserve 3 minutes for rebuttal, so I will keep an eye on the clock. Your Honors, this is a case involving disputed ownership of a 135 square foot triangular strip of land. The Nevilles have clear and convincing evidence that they acquired title to the disputed land by both the doctrines of 1, adverse possession, and 2, boundary by acquiescence. The Nevilles respectfully request that this court review this case de novo and reverse the lower court's decisions. The disputed land is located wholly within the Nevilles'
Which
right.
decisions do you want us to reverse? Because reverse means enter the opposite decision. I would think you're asking us to vacate, or are you actually asking us to enter summary judgment in your behalf?
Well, at least to vacate the lower court's decision so we could allow the clear and convincing evidence that we're going to discuss to go back to the trial court. And with respect to attorney's fees, if it is decided that there is clear and convincing evidence and summary judgment wasn't proper, then we would ask that award to also be vacated. Thank you. The disputed land is located within the Nevilles' gravel driveway, which is bounded on one side by brown concrete curbing that was installed by the Becks in 2004. Since 2004, the Nevilles believed that that brown concrete curbing that was installed was the property boundary line between the two properties. So the first evidence of clear and convincing evidence that the Nevilles would like to present or have presented is with respect to adverse possession. Their possession was actual. They used the property and they freely maintained it. They used the entire driveway to make use of a driveway as people do. They parked their cars on it, they accessed their backyard on it, they drove on and off of it. It was open and notorious. They freely used it and they used the entire driveway. There were also different colored rocks on each side of the brown concrete curbing. On one side there was the gravel that belonged to the Nevilles' driveway, and on the opposite side are the granite rocks that were installed at the time that the Becks installed the brown concrete curbing back in 2004. The use was hostile. The Nevilles told others not to go on their land. In fact, they told the Becks not to use the land, not to let the Becks have their invitees park there or their landscapers cross that property.
Did they distinguish between the entire driveway, which it looks like from the photos in the record, probably 75% of it was actually the Beck's property, or the Nevilles' property, and the 25% that the Becks claim? Did they, in their claims of right, where they said, get off of that, did they specify the entire thing or just their driveway as a whole? I mean, in other words, what I'm saying is, I can see them perfectly, even setting aside the issues of adverse possession and everything else, saying, hey, you can't park in that driveway because it's 75% ours, versus you can't park in that driveway because it's 100% ours. Did they ever make that fine distinction?
Your Honor, I'm not aware that they did. However, in looking at the photos, which are in the record, I believe item 17, and I have copies of the photo as well. I think they're marked Neville 7 and 8 that was attached to the supplemental statement of facts. You can see from the photos that there's only gravel in the Neville's driveway. So clearly, when looking at the differences in the rock and that concrete boundary, they're different colored rocks.
The boundary doesn't make any difference to me. I don't see what difference, the Becks are the ones that put the boundary in, correct?
Yes.
Okay. So the boundary, I guess maybe it's an evidentiary or a little bit of evidence of where the property line is claimed to be, but even if there was no boundary there, if your clients had said, this is our land, and anytime the Becks crossed foot into it, they went out and shoved them back across it and said, this is ours, then it really doesn't matter whether there's a boundary line there, right?
Yes, I would agree with you,
Okay.
Your Honor.
So to the extent there's an error below, it's in whether the trial court ignored your evidence proffered that there's a factual issue as to whether they did this hostile and under claim of right. In other words, did they say, don't park there, this is our land, correct?
Yes. Although
Okay.
my clients did provide declarations under oath and penalty of perjury that when the Becks asked if they could park in the driveway, I'm not exactly sure specifically what portion of the driveway, but they were always ordered off of the driveway. And when they asked permission, it's almost an admission that they were asking if they could use the driveway.
There's a difference between the driveway and a small portion of the driveway. So the lack of differentiation between our portion of the driveway and this disputed portion of the driveway gives rise to the question, did they exclude them from the whole driveway, which they were entitled to exclude them from their portion of the undisputed portion of the land? You would agree with that?
Yes.
So, go ahead.
However, the portion of the driveway where it was located is toward the end of it. So a car driving on top of it is going to have to cross that triangular portion in order to access the driveway. When looking at the photos that are in the record, the gravel is across that entire area. The Becks...
It would have been impossible for the Becks to have a car parked and not be, at least in part, on your client's land, though.
Well, we actually ran measurements. It was a footnote to our brief that a Cadillac Escalade could actually fit in that 135 square foot triangular portion. So if in fact the Becks had wanted to move that boundary before the 10 years had passed, they could have moved that and then there would be no issue. It's the fact that the boundary was there, and when you look at the rocks on either side, there was no attempt by the Becks to put that granite installation of rocks within that triangular portion to say, hey, this is ours too. In fact, 15 years...
But the Becks don't have to make an open and notorious claim to right to their own land. You're the ones that have to make the claim.
Yes, but...
And hostile and say, get out, right?
Yes, Your Honor.
Okay.
However, there was gravel all throughout that driveway. It wasn't confined to any one particular area. In fact, an ordinary person who was walking past it would see the gravel in that area plus the brown concrete curbing. And I think they have to come to the conclusion that this was the gravel driveway that belonged to the Nevilles, based upon the fact that there was this brown concrete curbing that was visible, and the fact that the granite rocks were only on the one side, the Beck side, and not on the Neville side, shows that there was no intention on the part of the Becks to extend into that triangular portion. Perhaps they could have done something about it within that first 10-year time period, but it's also very difficult to say the use wasn't continuous because that brown concrete curbing that was there in 2004 was replaced and reinstalled in 2014 in the same exact location. It wasn't until 2019 that the Nevilles even learned that there was an issue regarding the boundary. They always believed that that entire section belonged to them and had continuously used it that way and exclusively. And it wasn't just a 10-year period that was required by the statute, it was actually 15 years.
So run me through your best evidence to show, you talked about open and notorious, and let's say I agree with you on that.
Mm-hmm.
Your best evidence to show that it was hostile and under a claim of right is the affidavit that says we told them not to park here. Is there anything else?
Yes, and the fact that they continue to use it like an ordinary owner would, to the exclusion of everyone else.
I mean, they can drive down 3/4 of that or more because it is there. So what is the open and notorious that says we're not only claiming the 3/4, we're claiming this additional 72 2 inches over here, or whatever it is.
There's gravel over the entire area, and they could use that entire entrance at any portion to enter onto that driveway. And they did that over the last 15 years.
Okay, but again, not permissive, we're saying hostile under a claim of right. So what is the evidence that says, we assert ownership exclusive and are denying you possession of this?
Well, when the Becks asked if they could ever use the driveway to park their vehicles or vehicles of invitees or have the landscaper use it, the answer from my clients was no.
So that's I'm not trying to pick fights, I'm just trying to make sure. Is that the only evidence of the hostile and under a claim of right?
Well, there's that plus the continuous use and the intention to exclude other people from it.
And the evidence of the intention to exclude is we told them they can't park their cars there.
Yes.
Is there anything else?
Well, the statements were taken under oath, those particular declarations that were given by my clients, and they said they ordered the landscaper also to not cross onto the gravel driveway to access the Beck's property.
So no parking and keep your landscaper off of our land.
Yes. And additionally, since 2004, the Beck's landscaper has never maintained any portion of that gravel driveway. So there wasn't even an affirmative action on the part of the Becks to send someone over to that area. It just wasn't maintained by the Beck's landscaper at all. It was all done by the Nevilles, and they maintained that driveway continuously for the entire 15 years. If I may, I'd like to move to the boundary by acquiescence. So the second theory for the clear and convincing evidence of why the Nevilles are the rightful owners of this triangular strip of line relates to boundary by acquiescence, which is occupation or possession of another person's real property up to a clearly defined line. Here we have that 2004 concrete curbing that is a straight line embedded in the ground and basically permanent that served as the boundary. It's visible from the photographs in the record. If you look at the index to record item 17 at exhibit 5, there are clear photos. This line was visible from just about anywhere. From the street, the aerial photos, that line was there. The Becks never claimed that they never saw that there was a visible boundary or that the brown concrete curbing wasn't there. And in fact, in 2014...
You may have just said this, but what exactly are the elements of boundary by acquiescence?
So there are 3 of them. One is a clearly defined line. The second would be mutual acquiescence by the adjoining landowners as to the dividing line. And third would be the continued acquiescence for a long period of time, here 15 years. So, Your Honors, going back to the clearly defined line, it's clear even from space. If you look at the photographs.
From space?
Well, I don't know how high they're taken, but if we...
I know that the Great Wall of China is visible from space, but I don't know if the great boundary of the Neville Beck property dispute is visible from space.
Respectfully, I will argue that it is visible from above ground by a significant distance, that you can still see where the brown concrete curbing is and exactly where that driveway begins and ends. So the mutual acquiescence relates to the Becks not doing anything to correct that brown concrete curbing. In 2004, they put it in. In 2014, they did some additional landscaping work, and they put it in the same exact spot. And so that goes into my third point about continued acquiescence for a period of time. Presumably, it would be the same amount as adverse possession, 10 years, but here it's 15 years. Again, look at the rocks. There's 2 different types of rocks on each side of this brown concrete curbing. On the Nevilles, you have these tiny little pieces of gravel spread out through that entire area. On the Beck side, you have these much larger granite rocks that were installed way back in the time in 2004, and nothing was changed. And if the Becks learned, as they state that they did, that the boundary was, that the brown concrete curbing wasn't in the precise spot, they could have moved it. They could have done it in 2014, but they didn't. It wasn't until 2019 that we even hear about the dispute over this triangular portion of land.
What makes this a boundary? Because I can certainly imagine in my own property, I have hedges or shrubs that aren't on my property line there because for other purposes I may have decided that they're more aesthetically pleasing where they are.
There's pathways and things that don't necessarily demark a property line. There's things like that. So what makes this a boundary line that is, everyone who looks at it goes, oh, that's the boundary of the property? Looking at one of the photos in the record, it's certainly incongruous with the different fencing at the end of the brick way, which I would look at the fencing and go, that's probably the property line rather than this marking of the driveway, which could be just, we want to protect the trees or shrubs or rocks on the other side of it. So what makes this a boundary line?
Well, again, I think it's the rock. Because if you look at the two differences in the rocks, the gravel driveway is clearly the Neville's driveway. There's gravel all through it. When you look at the brown concrete curbing, it forms one side of it. So even if you are looking at either the aerial photos or the street level photos, it's clear that there is a driveway there of a sufficient width. And then where the brown concrete curbing starts is where you see the change in the color of rocks, and you start to see the plants and other items that are part of the Beck's property. And I don't think, being as short as I am, height doesn't matter. If there were shrubs there, if there was a giant wall, it wouldn't matter. It's still a boundary, it's a line. Even in driving on the road, your lines are your friends, stay within them. Here there is a clearly marked line, and it was permanent. It was embedded in the ground, and it wasn't even able to be moved until 2014 when it was uninstalled and then reinstalled back, a different concrete curbing, but in that same exact location. And it was at that point in time that if the Becks really were truly concerned about the boundary line, could have moved it at that time, but didn't.
Well, that presumes it's a boundary line as opposed to a decorative. I mean, why would they be concerned if they just viewed this as a decorative line to enclose their trees to the right of it?
Well, the Nevilles didn't think that it was a boundary line at all. They thought that's where they thought it was, wasn't decorative at all. They thought it was a boundary line. And clearly they acted that way because all of their gravel was flush up against that line. And you can see that in all of the photos, and you can see that in the change in the rocks. And naturally, one would think your eye is going to go to that line because it is a line that's there and that's permanent. And the conduct of the owners as well is evidence that that brown concrete curbing did serve as a boundary line, because when the Nevilles were using that driveway, they weren't crossing onto the Beck's property. They stayed within what they believed truly belonged to them. So I see that my time is almost up. I'd like to just summarize the most important points, if I may, regarding the clear and convincing evidence that the Nevilles have presented. One, the brown concrete curbing was installed in 2004, and the Becks never did anything to correct it. Since 2004, the Nevilles never let the Becks or the Becks landscaper or their invitees park on the disputed land or use it for access, and the Becks never protested. The Becks did nothing regarding their claim of ownership of the disputed land for 15 years, from 2004 to 2019. After 2004, the Becks landscaper never did any maintenance on the disputed land. Since 2004, there were different colored rocks on both sides of that brown concrete curbing. And in 2014, the Becks removed that existing brown concrete curbing and put new concrete curbing in the same exact spot. And lastly, prior to 2019, the Nevilles never knew that the Becks were claiming any of the disputed land. So thank you, Your Honors, for these reasons. We would like you to at least remand back to the trial court. Thank you.
Thank you, counsel. When you're ready.
Thank you, Your Honors. If it pleases the court, Steve Tully and Brad Dunn on behalf of Leslie and Steve Beck, our clients here today. In the pleadings, and you've heard today in the argument, the Nevilles continually refer to this section of their own property and the sliver of the Beck's property at issue in this case as a driveway. In fact, in their affidavits, they call it the Neville driveway. We understand why. There's no case law granting someone adverse possession for an unimproved waste area. But that's what this is. I think it's important to remember that the Neville's driveway is made out of concrete. It's on the other side of their property. It leads to their 3-car garage and to their house. No one looking at the Neville property would for a moment be confused as to where the Neville's driveway is located.
Okay. let's talk about this portion of the unimproved waste area. When we look at it, it looks like most people that have RV parking spots put decomposed granite and park their RVs there, not on their main driveway, so that they can use their driveway for ingress and egress. So when you call it unimproved waste area, if it was an unimproved waste area, we wouldn't be here. So let's talk about what they do use it for.
I think it's a good point, Your Honor, and I want to address that because initially, in their initial counterclaim, they asserted that this was a RV path and that they were using it. It was an RV driveway, is what they referred to it as you have. They removed that in their amended counterclaim because, of course, they don't own an RV, haven't owned an RV, and RVs are illegal in this HOA. And so it wasn't an RV parking area, as they've suggested. So when I say it's a waste area, it is essentially a waste area. You could park a car on there, sure, and people have over the years rarely parked a car there, but you wouldn't do it regularly. There's no evidence in the record, not the affidavits from the Nevilles, that they regularly parked any vehicles there. And the only evidence in the record is the affidavits from the Becks that it was rarely parked, there were rarely a vehicle was there. It'd be an eyesore, it's not convenient, and likely violates the HOA regulations to park a vehicle there.
Counsel, let me and maybe tip my hand a little. I think you've got a tough row to hoe because this is summary judgment. And so we're supposed to give every contested factual inference if it's a material fact in favor of the non-moving party. And they're claiming that in their affidavits, they're claiming that they claimed this property and told you you couldn't use it. What allows summary judgment when that's at least seems to be a contested fact? Now, I realize your clients say, no, they didn't, but isn't that what we want juries to do?
No, Your Honor, that doesn't qualify under the definition of adverse possession. Saying that I parked a car there occasionally is not...
Now, I'm not saying that parking the car there. The use is one aspect of it, but they claim that they told you couldn't use it.
Well...
Or did they not claim that?
Again, that is not... As you, I think, in your questioning correctly asked them, there's no evidence that they told the Becks that they couldn't use the Becks' own property. And you've mentioned that it was at least 75% the Neville's property. I think if you look at it, it's certainly much more so the Neville's property. There is a suggestion, which is frankly absurd, that you could park an Escalade on that property. You can look at the pictures. Until they make Escalades in a triangle shape, there's no way you're fitting it. I mean, they put in the footnote that it's 125 square feet or something, an Escalade, and this is 135 square feet. Look at the shape, right? There's no room, you couldn't get more than a tire and a half of a car that parked in this area would be on the Beck's property, right? That's what the evidence clearly shows. It can't be any legitimate dispute about that. We're talking about their claim. Now, what are the elements of adverse possession? It's defined by statute as the actual visible appropriation of land commenced and continued under a claim of right inconsistent with and hostile to the other. What did they do? What is the evidence that that is the Nevilles, take an actual and a visible appropriation of the Beck's land? The court below was absolutely correct. There's none. The Becks put the
Let her ask her
Counsel.
question.
I'm sorry.
There's a differentiation in gravel. There's maintenance of an area. There are all those things that say, this is mine, that is yours. How do you overcome that issue? So when you say there's absolutely nothing on this property, that doesn't seem to be a completely correct statement.
Well, then let me clarify it so that there can be an understanding. The evidence is here from the Nevilles, and they're the ones initially filed a motion for summary judgment claiming that there was no questions of fact, that this was a waste area, gravel there, right? It was a gravel area. They want to call it, they parked there beforehand, but there's only one side that has a concrete section on it, right? That there's just an open area there, right? They own the Neville's say they own that. That was the way it looked like beforehand, right? The Becks come in and they put in have their landscaping redone, and there's this row of pavers put in, right? Now, if you look at the adverse possession cases, the Nevilles have done nothing to appropriate the land of the Becks. They didn't put up a hedge. They didn't improve the property. They made no changes to their property, right? The Nevilles made no changes to their property. They did nothing that said, we're taking out this piece of property, we're flying the flag, it's our property now, right? And the cases are clear. I mean, adverse possession is a high standard. It's clear and convincing evidence that we're saying this is our property and we are doing something. We're putting up a fence. I mean, these cases where they find it, it's almost always fence cases, right? You're not going to find a case like this where the court found that someone had obtained property by adverse possession. This just isn't a fact situation where they find it because the Nevilles did nothing to say, this is our property and we're excluding you from it.
Is there anything in their declarations that says, we asserted a claim of right to this property?
No. No. All they claim is that they
told you couldn't park
the best
there.
day you couldn't park there. Well, it's their property. Most of it, right? I mean, saying you can't park on my property, it doesn't notify the Becks that, hey, and by the way, we're claiming a little sliver that's yours too. Nothing puts the Becks on notice, and there's no evidence that Becks on notice. And Judge Gates was absolutely right in granting summary judgment to say the Nevilles did nothing to assert ownership of this property as required under Arizona law for adverse possession.
How much does the standard for asserting adverse possession, that it's not just preponderance of the evidence, it's clear and convincing evidence, how does that interplay with our standard of review of a summary judgment motion? Does it change anything at all?
Well, it doesn't change the standard for summary judgment, I wouldn't think, but it would certainly mean that the amount of evidence they must have to defeat it would be higher, right? They'd have to have some evidence, produce some evidence that could meet the clear and convincing standard. And they didn't, and they don't.
In our review of summary judgment, we're to accept all facts alleged by the non-prevailing party as fact. And they have presented evidence or alleged evidence, would you agree, to meet the elements of adverse possession?
No, I completely disagree.
So tell me, what are they missing?
Well, they haven't taken an adverse act. They haven't taken actual and visible appropriation of the land that is the Nevilles. It's not that the Becks put this.
So in this
the Nevilles have to do it.
Okay, back it out and let's talk hypothetically.
Well,
let's talk
okay,
hypothetically.
but I've got to.
You and I are neighbors.
Yeah.
We have a border that runs between our property. All properties have borders. You put pavers down. We assume that up to the paver is my property, up to the paver is your property, and we go along for 15 years this way. So how do I show you open and notorious claim of ownership when we all assume that's the boundary?
You take an action on the property. You do something to appropriate the property.
Like?
Like put up bushes. That's a case.
Why do you have to put up bushes? I don't want bushes in my front yard.
What's that?
I don't want bushes in my front yard.
Then I guess the question is, why would they, my clients own the property, right?
Your clients put a border, what appears to be a border, along a piece of property
Right.
and didn't maintain the other side of it. What more do the Nevilles have to do to show that they are laying claim to that property?
Where they would have to maintain the property, or use it in a fashion that is adverse to us. And there's no evidence that they did so. In a manner that's very significant, that says, we are taking this property. And if you don't, if your neighbor puts up a border on your property, and if you happen to assume that that's the legal border, And then it turns out, such in this case, we have the engineers come, my clients, they got to redo their drainage in their backyard, and it's not. Well, okay then.
Explain to me how they asserted ownership of the portion of the unimproved waste area that they did own. How did they show their ownership? Do you see?
Well, no, I mean, Your Honor, my client's not making a claim for that property.
That's not what I'm saying.
Right.
I'm saying in Arizona, it's a little bit difficult because we have xeriscaping, et cetera. Maintenance of xeriscaping is maybe raking it, et cetera. But, I mean, what more can they show other than using the portion of the property under a claim of right, which is what we're supposed to assume based on the evidence they've presented? So help me differentiate in my own mind what they needed to do. They said they kicked people off when they parked there because it was their land. That's, because this is summary judgment, I have to accept what they're saying as true and find no disputed facts. So help me get there.
Well, Your Honor, I think you're, with all due respect, you're getting confused with the idea of they've got some disputed facts about whether they ever drove, how often they drove the car on, or whether they kicked off anybody, and the elements that the Nevilles need to prove in order to maintain their claim. And their claim requires that they do something to fly the flag. I mean, if you read these cases, it is a high burden to take property by adverse possession, and they must show that they did something that they showed an intent to take it.
Open, notorious, hostile, and under a claim of right.
Intent to take it, but there's intent. You have to show they intended to take that property of the Becks, that they did, and they did nothing in this case.
Would you think this is a completely different case if the Nevilles had put the pavers down?
Yeah, that would show intent to take the property.
Yeah.
That would be a different thing. And they cite a case, because there's so little cases, they haven't occupied the property in any sense. They haven't done anything to occupy it. Driving on it occasionally is not occupation. And if you look at even, they cite this Inch case.
Well, I've already tipped my hat, but I think that the only point that they have in their favor is that they claim that they told you couldn't park there, or you couldn't have your guests park there, or whatever. And I already highlighted, I think that there's an issue with respect to whether that is actually hostile to your claim of ownership over that little slice of that entire property. They can say, we're not allowing you to park there without even any reference to your share of the property. So that's where I'm kind of getting hung up on. But what I keep going back to, and what I think Judge Campbell was alluding to earlier, is, isn't that still a jury question, though? What did they mean by that? Or is it because the evidence, we've got plenty of evidence for their property, which is the plats and the boundary markers and the recorded evidence. That's how they prove that their property is theirs. What they're trying to do is overcome that, which requires clear and convincing evidence. And how do we review when a trial court has said there's no clear and convincing evidence on summary judgment? So that's where I'm kind of confused at. Is there ambiguous declaration about that property sufficient to be material to preclude summary judgment?
Your Honor, again, I'd go back. I think that Judge Gates got it absolutely right. And I don't know if I can say it again. I don't want to be repetitious or
as long as it takes 3 or 4 times to get things through our skull.
But the standard for adverse possession in this state is extraordinarily high. It takes an action by the Nevilles to assert control over property of the Becks. Assert control over the property. So they have to have done something. And leaving the property as it was before the Becks put up a border, if you want to call it a border, or a line of pavement, or whatever they want to do. Putting it out, leaving the property the same, doesn't meet the legal standard in Arizona. That is our opinion. I think it's absolutely the correct opinion.
I agree with you 100% on that, but they said they did something more, which is they claim they told you couldn't park there.
No. You only get to hostile if once they've met these are separate elements. Hostile, saying, hey, we can't use it. They've got to first meet, these are different elements of the claim. They've got to show first that they took an action to take the land. And then the question is,
that would be telling you can't park there.
Where it wasn't permissive, like parking there.
Telling you can't park is an action to take the land. If they
No. They're claiming that's a claim that their use of land was hostile to your use. But but that's not anything that puts the Becks on notice that they are claiming that they're taking the Beck's little slice. The Becks can't park a car on their slice of the property. I think we can all agree, and the evidence is clear and indisputable, despite the claims of counsel, that you can't park a car on that little triangle thing, right? So any claim, their claim of hostility is that the Becks asked to park a car on their own property, that is the Neville's property, and the Neville said you can't park it on our property. That doesn't do anything to notify the Becks, hey, they're claiming that they own my little slice of property. That's just not legally evidence of anything. And so no, I mean, so that's hostility. But before we even get there, they've got to show that they've taken an action to fly the flags, take the property.
Counsel, hold on. I'm going to ask you with your own language. So, hypothetically speaking, in this situation, or a situation similar, how would somebody fly the flag of ownership? And when we talk about intent to take, you say you have to intend to have taken it. Let's say we make a mistake to where the boundary is, and I have not intended to take it from you, I intend to possess it and own it. So intent to take doesn't mean I'm going to hold you up at gunpoint for your land. So can you answer those two questions for me, please?
Yes, I think I can, Your Honor. So first off, if the Nevilles had put up a line of rocks, or a line of border on the Beck's property, right, and said, this is our boundary line, and then improved the land up to that boundary, right? That would be some evidence that they were claiming that land, right? But that's not what occurred here. But if you were concerned about that, if you wanted to take some property like that, that's what you could do. And if you wanted to show dominion over it, you as you said, like some of the cases say, you make improvements to the property of the other, and you put something up there to exclude the others. Like I said, almost all the cases where they found it, it's a fence. And that's not what we have here. And so they haven't met the legal standard for adverse possession. And if I got 32 seconds left, I don't know if you're even considering the adverse, the second thing, the second claim of
acquiescence.
Acquiescence. But my clients, there's no evidence that they acquiesced to this at all. There's any sort of agreement about the property line or they did anything there. They couldn't legally acquiesce. The CC&Rs prohibit them from alienating any of their property without approval, right? So they can't sell. They can sell the whole lot, but they can't sell any portion of it at all. So they couldn't even acquiesce to this if they wanted to, and they haven't made any of the elements. I see I'm out of time. So,
thank you, counsel.
Thank you, Your Honors. I just have a couple of points. First of all, with respect to the driveway, it is clearly not an unimproved waste area. In fact, the underlying record shows that the only comment that was ever made by the Becks in any of their pleadings was that the RV gate did not properly open and close. But the driveway is a gravel driveway that has been maintained for the last 15 years by the Nevilles, which they have used as a driveway. I don't know if there's been an RV on it or not, but it's a driveway, and they use it like a driveway should be used, to access their backyard, to drive other cars on top of it. It's a driveway. Counsel, in his argument, just said that offense would be determinative of adverse possession. It isn't always. There are lots of facts and circumstances that go into whether someone meets the elements or at least provides clear and convincing evidence.
Can you point to any case in which an Arizona court has found adverse possession where the boundary marker was installed by the actual property owner as opposed to the person who's claiming adverse possession?
Yes. My apologies, I don't have it off the top of my head, but in our opening brief,
I know there's cases where it doesn't say who did it, but is there one where the court said specifically, despite the fact that the adverse possessor didn't put the boundary in, we're still going to find adverse possession?
yes, I'm trying to find it, but there was one where someone had put in various elements where the court did decide that it was on the opposite side. I think it had to do with mistake. So Higginbottom talks about whether the claimant has established the elements of adverse possession being one of fact, and then goes on to say, I believe this is the one where it went, where it was put in by an owner. I'm sorry, I know I've seen it, I'm just having trouble finding it. Well, there's one case, Trevelyan versus Reyes, 40 Arizona 42. The fact that a claimant had no intention of taking what did not belong to him, or that one or both landowners were ignorant of the true boundary lines, doesn't affect the operation of adverse possession.
Yeah, but that's not a case in which we have a shrub, hedge, boundary line wall put in by the owner, the original owner.
I don't know that I can find one in the time that I need.
We're actually out of time already, so.
Okay, thank you, Your Honors.
All right, counsel, thank you for the spirited discussion. We appreciate your arguments. We will take this matter under advisement and issue a written ruling in due course. We are adjourned.